Good morning, everyone out on the West Coast and in the middle parts of America, and good afternoon in the Eastern Seaboard in Washington, D.C. Thanks, everyone, for joining us. My name is Mike Kuykendall, and I am Senior Counsel for the National Association of Attorneys General, which represents the 56 Attorney Generals in the United States and territories on training and technical assistance matters. Today, we've got a very interesting presentation. It's presented by the National Center on Forensics, which is run out of George Mason University with federal funding from the National Institute of Justice. And so last summer, we had a large training in Manassas, Virginia for forensic scientists and prosecutors and law enforcement across the country. And at the end of that, we did a survey and asked what questions the attendees had that they'd like to see, and covered it more in a webinar format. And so that's how we ended up where we are today. We have about 8 webinars planned this spring at the NCF. Today's is a fascinating one. It's called Navigating the Headwinds of Forensic Science Admissibility. Is it time to trim our sails? And again, it's presented by the NCF. We've got Ken Melson, a former senior advisor on forensic science to the Office of Legal Counsel with the United States Department of Justice. He's got a 40-plus year career working on prosecution matters, and particularly in forensic matters. And so we've invited him to come in here today and talk a little bit about how far we've come with our forensic science admissibility, and is it time to slow down a little bit and smell the roses and see where we are based upon recent court cases and other scientific pitfalls. So Ken, we're going to turn it over to you. For everyone that's listening, if you have a question for Ken, just type it in the chat room, and Ken will get to it before the end of his presentation. And we expect this to last approximately an hour, give or take. So Ken, it's all yours. Thanks, everyone, for joining us.
Thank you, Mike, and thank you to all the individuals that I have seen before. Well, I'm not working this now. There we go. I'm sorry. Well, for those of you who were at the presentation last year, welcome back. It's good to be with you. And for the new participants, I'm honored to be able to present this to you today. So the presentation is really about kind of what Mike said, to smell the roses, because we have made progress, but there are things on the horizon that we need to make sure that we don't create more issues for ourselves. And we have to kind of trim our sails by adjusting our standards and our processings to the evolving law, so that we don't step into situations that create bad facts and thus bad law. So welcome. Let's get started and see if we can talk about the outline. We'll sail into this issue real quickly. The first, we're going to talk about changes in the federal rules of evidence, and then we'll talk about the current litigation in the Supreme Court. There are 2 very interesting cases that are pending decision that you should know about and expect and get ready to deal with. Forensic investigative genetic genealogy, the legal issues more than the scientific issues with respect to that. The rise of standards in the courts, which I spoke of in the session before, but is very important for purposes of our going forward. And then finally, some recent firearms cases, including one that was decided 3 days ago, which I was pretty excited about and still am. So let's start off with the federal rules of evidence. Now, I know that many of you don't practice in federal court, but many of your states follow the federal rules of evidence. So it's interesting to know this because there may be some spillover to your courts. So remember Federal Rule 702, I'm sure you're all familiar with that. It was amended in 2 regards. The first one is in the beginning of the rule, which emphasizes that the proponent of the evidence that's going to be introduced has to prove it to the court or demonstrate it to the court that it is more likely than not that the testimony and the analysis is and was reliable. More likely than not is the same as preponderance of the evidence. Now, this is somewhat of a non-substantive change because Rule 104 in many courts held that that was the burden to begin with. But the Rules Committee changed the Rule 702 because many of the courts didn't make that determination that it was more likely than not that it was all reliable. They instead left it up to the jury and said the questions about the reliability go to the weight of the evidence, not the admissibility. And that was not what the Supreme Court intended. And so the Rules Committee changed that to make sure that they understood what the burden of proof is. Now, I personally think that the best practice is when you have a Daubert hearing on the admissibility of scientific evidence, that you make sure the court makes that finding on the record. So there's not that issue later on as to whether or not the proponent of the evidence, usually the government, actually met the burden of more likely than not. That's the best practice. And if you don't hear it from the court, I'd ask the court to make that determination. And also note that the more likely than not standard doesn't really apply to the qualifications of the expert. It applies to the reliability portions of 702 in A through D. One court already has indicated that you don't have to make that finding as to more likely than not if there is not an objection. And that makes sense. But if there is one, ask the court to make that determination. Now, the second part of the amendment refers to portion D, and that is they struck out expert has reliably applied and inserted expert's opinion reflects a reliable application. So that is a nuanced change. It's not meant to be a substantive change, but it focuses the court on the fact that you have to have a reasonable basis for the opinion based upon the reliable application of the methods and so forth. So in the committee's notes, it talks specifically about not making an absolute or 100% certainty determination, or to talk about a reasonable degree of scientific certainty. And you know that was kind of banned by the Department of Justice for its federal laboratories and prosecutors not to use that reasonable degree of scientific certainty. Although in a footnote to the note, it indicates that, if the law of the district or the state requires it, then you can use that term. It also goes on to emphasize feature comparison evidence. And that was the object of the PCAST report. And they pretty well fallen in line with the PCAST report. And what it emphasizes is you have to have the testimony can't give an inference that can't reasonably be drawn from the reliable application of the principles. So this goes back to the analytical gap that the Supreme Court noted in Joyner, which says if there's a big gap between the expert's opinion and the reliable application of the methods, then there's a problem under Daubert. So this just makes sure that the courts follow this thought process. So one court already in Tennessee said that the rules are not substantive. And I indicated that earlier that was true, but here we have a court already saying it's not substantive, but it's still better to make clear what the rules require on your record. So let me talk about a couple pending U.S. Supreme Court decisions, both of which have been argued and both of which are waiting a written opinion. And I keep checking to make sure that the opinions haven't come out by the time I made this presentation. So the first one is Smith versus Arizona, and that deals with how you present a substitute expert. So when the analyst is unavailable and cannot testify, and you call another expert to testify to the results of the non-testifying expert, we have to follow certain procedures because if it's a mere surrogate or he's just a conduit to the non-testifying expert, then we may have a violation of the Sixth Amendment, which is set forth below, which talks about the right to be confronted with the evidence or witnesses against him. So let me give you a little prologue to this case, because you'll see the progression and can anticipate and understand better, perhaps, what the reasoning of the court will be. So back in 1980, the Ohio versus Roberts told us that if there's an out-of-court statement, but it has an adequate indicia of reliability, then it comes in as a hearsay exception, if it's one of the firmly rooted hearsay exceptions. Then we get to 2004, and the court changes that completely. And it says really that hearsay is irrelevant to the out-of-court statements. It's whether the individual who made the out-of-court declaration is unavailable, and did the defendant have a prior opportunity for cross-examination. In that case, though, they left the definition of testimonial for a later decision, but it said it applies pretty clearly already to prior testimony at trial, a preliminary hearing, grand jury, or police interrogation. But we weren't sure what the definition of testimonial was. Well, then came 5 years later, Melendez versus Diaz, where the prosecution attempted to just present a piece of paper, which was the laboratory report. And it was admitted for its truth at the trial without any expert background information or expert witness support. And they said that this report was created for the sole purpose. And I emphasize that because you'll see how the definition morphs a little bit. So it was created for the sole purpose of providing evidence and came within the core class of testimonial statements. So we know that the laboratory report alone is testimonial, and if offered for the truth of the matter, is inadmissible. It also said something that was important, and it's a theme that goes through these cases. And that is, the court didn't say that the background information about how the test was performed or the standards or the accreditation, all that type of basis evidence was inadmissible. What it says is that can be done by somebody else, like a fact witness who can come in and testify to their personal knowledge about authenticity, chain of custody, and the testing device, and so forth. Also interesting in Melendez-Diaz was Justice Thomas, who started to talk about what is testimonial, and he says it is a formalized type of document that has a degree of solemnity to it. So if it's signed by somebody, if it's on the letterhead and signed and maybe notarized, then it has such a degree of solemnity that it is in fact testimonial. And you'll see that his theory of testimonial materials follows through in the rest of the cases, and he concurs or dissents depending on the issue in the case. Bullcoming came up in 2011, and that was another case in which a forensic laboratory report was admitted into evidence and for the truth of the matter, but this time they had a supporting expert who came in. But the problem was that the expert didn't do the analysis, didn't see the analysis, didn't observe it, and didn't develop their own opinion on the results of the analysis. So when that was admitted for the truth of the matter, the court coined these phrases of surrogate testimony, or a report as a testimony, and the report as a testimonial certification. So surrogate testimony is what we're trying to avoid. And here Sotomayor, Justice Sotomayor, wanted to better define what is testimonial, and her test was primary purpose, which eventually became the leading definition of testimonial. What was the primary purpose? Finally, we had in 2012, Williams versus Illinois, and you remember that because it caused a lot of confusion. It was just simply a plurality opinion where the testifying expert relied upon Selmark's analysis of the evidence DNA to develop a profile. Then the testifying expert from the state lab compared the known DNA from the defendant to the evidence DNA profile prepared by Selmark. And she said it was a match in essence. So that report wasn't admitted for its truth, and it wasn't prepared according to the justices for the primary purpose of accusing the defendant. Because when Selmark did its analysis, they were looking for somebody. They didn't know who it was. They were just trying to identify someone. So it wasn't for the primary purpose of providing evidence in court. And therefore, it was not testimonial, and it came in. Again, Justice Thomas talked about formality and solemnity as the issue for deciding whether something is testimonial or not. So if you looked at three cases, in Melendez-Diaz, the report was testimonial and it was introduced for its truth. In Bullcoming, it was testimonial and it was introduced for its truth. And in Williams, it was not testimonial for the reasons I just stated there, and not introduced for its truth. And the contents were not offered either for its truth. So in the Williams case, we had a whole different number of justices that were in the majority. So in Smith versus Arizona, the defendant was charged, and the testifying expert in that case, according to the Court of Appeals, testified to his own opinion. And the Court of Appeals says the opinions and work product and report were not admitted in the evidence, and the expert, the testifying expert, was not a mere conduit of the non-testifying expert. So and that the defendant could have called the non-testifying expert to the stand if they wanted that person there. I don't think the Supreme Court is going to address that particular issue. In any event, the Arizona Supreme Court denied cert, and yet the Supreme Court took it up. And they're going to determine the ability of a testifying expert, a substitute, to testify to an opinion that he or she independently formed. And the outcome of this case, I think, is going to be dependent on which justices pick which facts to rely on. And you'll see a little bit of this as we go along. So it's going to be fact dependent and who is going to be in the majority. So now if you look at the justices that were involved in Melendez-Diaz, you had the justices you see here, but Scalia is not there anymore, nor is Stevens or Souter or Ginsburg. So that took out everyone but Thomas that were in the majority. And with respect to Bullcoming, similarly, Scalia was not there, Ginsburg is no longer there. So that leaves the new Justice Kagan, along with Thomas and Sotomayor. So in Williams, again, Scalia is not there, they descended, Ginsburg is not there. So really what this kind of does is leave Kagan and Sotomayor, which were in the majority in two and in the dissent in the third, to butt heads with Thomas, Alito, and Roberts. And Thomas may be on the fence on that. So the questions in Smith versus Arizona that were propounded by the amicus and the state and the defendant are interesting, because the defendant said they talked about the testimonial statements of a non-testifying forensic analysis being conveyed. The state narrows that to the notes that the testifying expert may have relied on. DOJ narrowed it even more to the data from the laboratory. Then that's what the expert relied on, and therefore it was permissible, because it was not a statement of a non-testifying expert. So one of the questions in the case is, what about 703? Because we all know that experts can rely on evidence that's not necessarily admissible if it's reasonable to rely on those kinds of facts or data informing the opinion to begin with. And they don't even have to be disclosed to the jury. So that was an argument, and Justice Roberts kept asking, are you trying to get rid of 703? So 703 is still going to play a role in their decision as to what can a testifying expert rely on under 703 from a non-testifying expert of anything. But again, the question is always, would 703 trump the Sixth Amendment? So did the testifying expert convey the statements of the non-testifying expert? Well, these are the three, you see the three documents which might be in question: the reports, the notes, or the data. Those are the three. And it's interesting to note that during the trial, the testifying expert kept asking permission to refer to the report. And that was a misnomer, because in the argument, they kept saying that the information that he then gave didn't come out of the report itself. It came out of the notes or the data. But someone like Sotomayor and Kagan, those two justices, may indeed hold on to that indication that he was talking about the report, which is clearly testimonial. The other thing they kept relying on, Justices Sotomayor and Kagan and Jackson, were the testifying expert used the same exact language for the conclusion of the report that the non-testifying expert had in her report. Well, they tried to make clear that that is the normal testimonial result from any analysis of controlled substances. It is the substance was whatever it was, cocaine, meth, or whatever. And they didn't quite I don't think the justices quite understood that. So if they did rely on the reports or notes or data by the testifying expert, what is the test that's going to be used to determine whether those are testimonial? And you see the primary purpose test that Justice Sotomayor wanted to impose, and Justice Thomas's formality and solemnity test. And during the argument, Justice Kavanaugh kept trying to implicate that test as something that the state and the Justice Department should adopt. Excuse me. So what is testimonial? I think the report obviously is going to be testimonial because of the two prior cases. The notes may be testimonial because they provide basis evidence, and the testifying expert should have testified to that basis evidence as a fact witness. Like was said earlier in Williams, you can have somebody who has personal knowledge of the laboratory processes and quality assurance program and testing methodologies come in and testify to their personal knowledge as to what happens to a substance when it's submitted to the lab for analysis. Hopefully, the data won't be considered as testimonial, because all the expert really had to do was to review, if there was a fact witness testifying about the basis evidence, is to review the results of the GCMS and testify that what that meant was that that is this type of controlled substance. Now, as I said, it depends on the facts of the case, and Justice Sotomayor argued that Arizona had already conceded the testimonial issue. So we kind of think, we kind of know where she is going to be going in this particular case. It's interesting to note, again, that the Deputy Solicitor General in their amicus brief talked about the basis evidence. And he again stressed, and this is a good lesson for us, is that we could have someone as a fact witness come in and talk about the forensic standards that are required, the accreditation system, the quality control system, and all of that, because this is what we invariably do. It's the basis evidence. So remember that fact witnesses can do this, and the testifying expert doesn't necessarily have to do this. Although, as we'll see, you could have a hybrid witness come in and testify as a fact witness, and then the expert witness on the conclusion. And that's a hybrid witness, and you'll have to discuss with the court whether you have to have jury instructions so the jury knows which was fact and which was expert. Okay, so here's another pending Supreme Court case, and that deals with the mens rea of the defendant. What knowledge did the defendant have concerning the particular crime involved? And that revolves around the ultimate issue. Now, Rule 704 of the federal rules, and remember, many states adopt the federal rules, say that generally it's not automatically objectionable if the opinion goes to the ultimate issue in a case. After the Hinckley case, they put in an exception to that. And that is, you can't state an opinion about whether a particular defendant has a mental state, such as knowledge or something else, which is an element of the crime charged or a defense. All right, now, this is a federal rule of evidence. It's not a constitutional rule. I did a survey, although informal, of all 50 states, and it shows that subparagraph B, the exception, has not been incorporated in most states in your rules of evidence, except for Arizona, Louisiana, Utah, Missouri, Georgia, Virginia, Maryland, and Connecticut, and Indiana. So there is a number of states that have adopted that. And if you're from one of those states, this opinion may very well be important to you. So there's a split in the decisions, in the circuits rather, about whether or not, and this is the issue in the Diaz case, is if you have class-wide testimony. In other words, if I come in and say, every courier that crosses the border with drugs in the car have to know that they have drugs in it, because that's the way it always occurs. Now, the Fifth Circuit said, no, you can't do that because you're talking about the mens rea of the defendant, because they are by the charges, specifically included in that class. Therefore, you're violating 704B. Well, the Fifth Circuit rejected that testimony as a violation of 704B, whereas other courts like the Ninth Circuit say that this testimony is admissible if it's relevant and probative of the defendant's knowledge, even if it's class, or even if it has other circumstantial evidence that reflects on the defendant's knowledge. So U.S. versus Diaz is now in the Supreme Court. And this was a mule who was taking drugs across the border. And her defense is that she was unwitting. She had no knowledge that there were drugs hidden in the panels of the doors, the front doors of her car. So the government introduced a DEA agent as an expert on the general structure, the modus operandi, the operation of the drug trafficking organization or its framework. And the defense argued that such testimony violated Federal Rule 704, which is the issue in Diaz. Well, remember that, going back to the rule, that opinion on ultimate issues are not automatically objectionable just because it embraces that issue. But even if that turns out to be the case, it's not necessarily admissible unless it passes the scrutiny under these three rules that I have listed here: 403, 701, or 702. So the opinion on an ultimate issue then will depend on whether or not it falls within 704B. So the court is going to have to determine whether this class information that might include the defendant is in violation of 704B, or whether it's only an individual an opinion about an individual's knowledge that violates 704B. So let's take a minor tack for a minute from this case to talk about an issue that really applies both to Smith and to Diaz. So
how could you be so sure? Because there is no way that these tire marks were made by a 64 Buick Skylark. These marks were made by a 1963 Pontiac Tempest.
Objection, Your Honor. Can we clarify to the court whether the witness is stating opinion or fact?
This is your opinion?
It's a fact.
All right, so that raises the issue of fact versus expert testimony that I alluded to a little bit earlier. And it's interesting to know that in Diaz, Justice Alito during the argument said, I don't know what reliable principles and methods could lead anybody to conclude that every single person who does that is the importation of drugs, knows what's in the car. So he's suggesting that maybe there is a proper attack on that type of expert testimony under 702. And the Fifth Circuit, in the case we talked about earlier, said that type of testimony can't fairly be considered expert. So the question is whether or not you can get that same evidence in by using a fact witness, a lay witness, fact testimony, or do you have to use expert testimony to get it in? Now, there's a split in the circuits on whether you can use fact testimony to get that information in. And this case talks about the distinction between expert and lay witnesses, which is the type of testimony that they're giving. So you might be able to frame very easily an agent's testimony about his lay opinion based upon his personal knowledge of the cases that perhaps he was involved in, or even others, and not give an opinion, just lay the facts that which you can put together in closing with other circumstantial evidence that shows that the defendant knew the drugs were there. All right, so there are some things coming our way in which we may want to look at trimming our sails. You see the buoy and the rocks there. So let's talk about some of those. And right now, let's try and figure it out. That's not a misspelling. So let's talk a little bit about forensic investigative genealogy. And I know there is something on the NCF website that talks about the actual operation of forensic investigative genealogy. I want to talk more about the legal aspects that I've been able to find in the last couple months. So remember, forensic investigative genealogy, forensic investigative genetic genealogy, I missed a word there, is also called investigative genetic genealogy or genetic genealogy. So all those are kind of referring to the same. It depends on the group that is talking about it. But one thing that is important to know is the tremendous success that the forensic investigative genetic genealogy has had since 2018. And in this presentation at the NAS committee on FIG, the doctor testified that there are over 1,000 cases that have benefited from it. So and I say that only because it's very important that we stay within our lanes on doing FIG so that we don't create bad facts that will create bad law. So there has been some law on it, not much. So in 2023, just a while ago, in Washington, State versus Hartman was decided, and the defendant there argued the unconstitutionality of what they described as a warrantless and suspiciousless search by state actors. So that's one thing I want to remind you. If the lab outsources the FIG to another laboratory to do the SNPs and for the search aspect of it, that they are state actors. So the defendant here argued that he had a privacy interest with his family members in their DNA. And particularly the common DNA that they had voluntarily updated to a public database. The court said that the defendant did not have standing. So there has been an interest in determining what actual standing does a defendant have when contesting the use of FIG. The State versus Phillips case also indicated that there's no property or reasonable expectation of privacy in his DNA related to his relatives. He indicated, or that judge indicated, that it was a legislative issue, and you'll see some legislatures are beginning to take this up. Here are some other cases which were decided relatively recently. And they all involved FIG. They didn't necessarily discuss the FIG, but it's interesting to note that in Carbo, they said there was no warrant needed to conduct the FIG search. That's important, but you've got to look at your legislation. In Burns, they argued that the police needed a search warrant to analyze the DNA from the straw that they used to get the DNA sample to compare with the evidence sample. I mean, that issue has been around for a long time, and the court in Iowa denied that as well. And in Bortree, there was a statute of limitations issue there. And apparently they did not file John Doe warrants back before the statute of limitations expired. And so they opened this cold case after the statute had already expired. And this may point to the necessity of remembering about John Doe warrants with respect to these cases. So here are some other issues to consider. One, when to disclose the use of FIG. Now, the cases that I've read and other information, some describe it in the warrant, others do not. Lepere, they argued the lack of probable cause in the search warrant. And in State, Corbett versus State is an interesting one because they had a kind of a neat theory here. So there were three substantive facts in the Corbett case. One was the anonymous tip to the investigative defendant, which was the information from FIG, but they didn't disclose it was FIG. They just said it was an anonymous tip. The knock and talk at the defendant's home, which they did to verify that the defendant actually lived at that particular address before they did the trash run, and then the constitutionality of the trash run. Their argument was that the knock and talk and the trash run were unconstitutional. And if that was the case, then the anonymous tip is uncorroborated, and therefore the warrant fails. So that was an interesting approach, and maybe some impetus to put in your warrant the FIG information. So other issues to consider. How about the status of the laboratory? Here in Texas, the lab was not accredited by the Texas Commission of Forensic Science. This was not a state laboratory. And one of the lab analysts was not licensed by the Texas Commission of Forensic Science. So the court was able to work around those two issues, particularly with the lab analyst, because she was only conducting batch work and didn't need to be licensed. But so you have to look at your state law to make sure that whoever is doing your SNP and your search have complied with whatever licensure or accreditation requirements are required in your particular state. Other issues are discovery. Now, you're going to, I think, see a lot of courts coming down differently on discovery issues, depending on perhaps the issues in the case. But you all know the Kohlberger case, and here is a cite to the order which addresses here he calls it IgG DNA, and the issue of discovery. And you can also look at the Idaho Judicial Cases of Interest, which goes through all of the Kohlberger orders and motions and so forth. So that's a starting point to read that order, to look at the issues that you might approach in a FIG case. So that's what the Kohlberger report did. It reviewed the cases relating to FIG and discovery. How about state laws? Well, there are some state laws, two in particular. One is Maryland, which is very restrictive and which involves the judiciary at almost every step. Many of the prerequisites for doing FIG, you have to have a search warrant for. You can only use certain types of genetic databases. You have to have the SNP laboratory license. There's another one like Texas. You have to have informed consent of a third party request for DNA sample when you're developing the lead and doing the searching and so forth. And then you have to have a warrant in order to do covert collection of the DNA of the suspect's known DNA from things like a trash run or a soda or a coffee cup or something like that. So you've got to look at your state laws. Now, Utah has one as well, and they're beginning to develop that statute. You should look at that. There's the website. And another place to look is at the survey of state genetic privacy statutes, because these privacy statutes were passed prior to the use of FIG as an investigative technique. And the author of this particular commentary talks about the unintended consequences of these privacy statutes that were drafted prior to the use of FIG in many cases. The other thing you need to look at is the federal interim policy on the use of FIG. We've mentioned that at the conference as well as other times. It applies to federal law enforcement agencies, but also to state and local agencies that receive federal funding. So this federal interim policy is an umbrella over everything else, and almost every state laboratory and many local laboratories have some sort of federal funding, something from Coverdale or other, and maybe even law enforcement funding. So you have to be careful and be familiar with the federal interim policy. Now, there are things being written of what the defense approaches are to FIG. And if you look at this primer for defense attorneys, you'll see in Chapter 5 and Chapter 6 discussions on building a record in your FIG case and discovery and Fourth Amendment challenges. They don't have a lot, I think, to stand on, but this author indicates that there are certain approaches that defense attorneys should take. Now, I also want to point your attention to the fact that the National Academies of Sciences is having a number of groups come in and talk about FIG and talk about the use of FIG. In fact, if you see down here in the actual website, the law enforcement use of probabilistic genotyping, DNA phenotyping, and forensic investigative genetic genealogy. These workshops have people come in and talk about it. I'm not sure what what's going to come out of these, but you ought to pay attention to them. In this particular presentation, the presenter had a couple takeaways, and one is that, good for us, there's strong public support for FIG, and it hasn't changed over time over the last several years. Now, this is important because we have to keep our public support for FIG. We don't want to get involved in situations where the public reduces its support because of something untoward that law enforcement or prosecutions have done. So the other thing is that many prefer that there is some sort of regulation for FIG. And so that is what I was saying, you need to keep your eye on with respect to your state and federal laws and policies and so forth. One of the things you can use if you're looking for a basis for policies regarding FIG, look at NTVIC is what we call it. It's the National Technology Validation and Implementation Collaborative. They've got a lot of policy suggestions regarding the use of FIG. And this group has a very diverse network of people involving actual forensic practitioners, prosecutors like Ray Valerio, and also many of the corporate companies that do the FIG as an outsourced possibility. So that takes care of FIG. Let's talk a little bit about the standards that we are employing now. What are the rules of the road? So the sailboat on your left is going to be interfering with the sailboats on your right. So what he is going to have to do is find a way out of the potential crisis. So we have to look at the rules of the road for us to avoid issues that may not be satisfactory to us. One is standards. What are the standards in general that we need to abide by and make sure that we emphasize in court? Because as you have seen in some of the previous Supreme Court cases we talked about, at least those of Justices Alito and Roberts kin have emphasized the value of these types of general standards, such as laboratory accreditation. All of the state laboratories are accredited now. We have to look at getting more of the coroner and medical examiner offices accredited as well. The individual certification is important for the analyst to kind of bolster or support their credibility that they've been certified to do this work by an independent entity through a testing regime. The OSAC consensus-based standards are important. They have the registry, as we spoke about at the conference, based upon this consensus building. And the academies, the American Academy of Forensic Sciences Academy Standards Board and other SDOs, Standard Development Organizations, work with OSAC to develop these American standards, which are a consensus-based standard that is developed through the requirements of the accreditation for those boards. So additionally, you can see that OSAC has gone out and interacted with laboratories, and they have 152 laboratories that have self-declared their use of OSAC standards on their registry. It doesn't mean every discipline they use have the OSAC registry standards, because there are not standards for every discipline at this point. And you can see the various types of entities that have adopted those standards. So that's important for you to inquire of your laboratory with respect to what they actually use as their standards within their laboratory. So we also have reporting standards. Now the DOJ has the ULTRS, the Uniform Laboratory Testimony and Reporting Standards. These are designed to give guidance to the DOJ examiners in the DOJ labs. But remember, if you are a state case and you have the analysis done and you send it to the federal government to prosecute to the U.S. attorney, you may have to work with them and your expert to modify their opinion to comply with the ULTRS. And there's the website for those. Other reporting standards? Well, we have a number of cases in the firearms identification area. Now, here is a case out of Kansas in March of this year, where the court stressed the standards, the SOPs, accreditation, certification, validation procedures, and all of that to support the admissibility of firearms identification. And this court said specifically that the DOJ alters are reasonable, and that is what was imposed upon their experts' testimony and his opinion. So these are relatively easy to accomplish. I don't know of any cases that you're losing the case because you used an alter. And I think that's a pretty good way to trim our sails and to use those when the expert testifies. Unlike an expert may testify who's a member of AFTI, for example. All right. Now, there was this case out of Maryland just recently, though, and I say CF because this is a 180-degree turn from the previous case we talked about. Here, the victim was shot 5 times, and they got bullets and fragments from the crime scene. And the question is whether the firearms and tool mark examiner could make an ID of a specific firearm from which these bullets and fragments were discharged. The court talked a lot about error rate and inconclusives, like the PCAST report did, and how do you count those, the inconclusives, for purposes of error rate and so forth. And they were very negative concerning firearms identification. And they even indicate that the value of some of the standards and controls that were presented to the court were undermined by the fact that, number one, reviewers always agreed with the primary analysts that the proficiency tests were way too easy, that the sufficient agreement didn't have any guidance for or threshold on whether or when you meet the sufficient agreement definition. And then also talked about the issue that has been around for a long time, which is the subclass versus individual characteristics of the discharged bullet or casing. So the court there said that the analytical gap between the opinion and the empirical foundation, remember going back to subsection D of 702, was too large. And so the expert can't give an unqualified opinion. And that was a 4-3 decision, which means hopefully there's still some room in the future to kind of change the analysis by the Maryland Supreme Court. So the court's decision, according to Professor Kay, who I hope you follow and read, because he's an excellent, well-known professor regarding forensic science, and his blog is down there. He says this is the first time that a Supreme Court, as opposed to lower courts in states, has unequivocally held that the examiner cannot testify that a bullet was fired from a particular gun. That is, without any type of disclaimer about the attribution and its scientific or practical certainty. So that, according to Professor Kay, is kind of an initial, for a time being, landmark case, because it was by the Supreme Court, by a Supreme Court opinion. Now, if you also look at Professor Kay's discussion on inconclusives and error rates, this is also in his blog, and he takes that opinion and discusses whether or not the court or PCAST is right regarding whether or not inconclusives should be regarded as errors or not. All right. Now, just today, a court case came down, which was decided just, or at least was issued just a couple days ago on April 19th. And this is an interesting case because for a long time, you'll see some cases like coming out of, I think, New Mexico and Arizona that talk about these professors that come in and testify about a particular discipline. And most of them are in the firearms identification area, in which they have never made such a comparison, haven't been in a laboratory, were never a forensic scientist, they're just legal observers. So in this case, in Randolph, the defense wanted to introduce Dean Fagman as an expert witness. Now, many of you who have read about cases, including the one we just spoke about, I believe, Fagman has been an expert witness. And he talks about the foundational validity of firearm and tool mark identification. But the thing is, he hasn't really ever done it. So in this case, the Middle District of Florida District Court judge said that Fagman is an allowable witness for Daubert hearings on admissibility, but not during trial, because he said it would confuse and mislead the jury. So that is a very recent case, which I think is very much to our benefit in ongoing cases, to keep someone with Dean Fagman's tremendous CV out of the courtroom and out of the front of those of the jurors, and leave him to the foundational validity in the Daubert hearing. So that's all I have for today, and we're coming up upon 1 hour. But remember that knowing the law, the facts, and the science in your case is going to get you across the finish line in heroic fashion. Thank you.
All right, Ken. Thank you very much, everyone. Mike Kuykendall here again at NAG. We did do a taping of this session, and it'll be posted on the National Center for Forensics website here shortly. We also have all the sessions from our August training in Manassas, Virginia last year on there as well. And there's some excellent material there if you'd like to check it out anytime. The way to find that is just go online and put National Center on Forensics, George Mason University, and that'll take you right to the link. So again, thank you all for joining us today. We appreciate it. And Ken, can't thank you enough. Been great working with you, as always.
Thank you. Same here.
All right. Have a good day, everyone.